Welcome back to It's Your Law. I'm George Curtis, and my guest today is attorney Mike Siddall, a senior partner with Hurling Clark, and admittedly a kind of a conservative, careful guy who backed Governor Walker, and lots of people did. Governor Walker won fair and square. But since he got in, there have been many, many changes, some of them overwhelmingly fast striking changes, because he not only had the support of the electorate, probably the Tea Party, he had the majority in both houses of the legislature, so he could do what he wanted. Some of the legislation to me was absolutely shocking. And on the similar train of what we discussed about I'm sorry legislation, which has not yet been passed, and I hope it doesn't get passed in its present form, but there were some things passed about investigative reports in hospital and nursing home records. Mike, would you explain that, please?
Sure. That's already law. The law prohibits investigative reports in nursing homes that may have investigated an abuse situation from being admitted in a civil lawsuit or in criminal lawsuit with the district attorney's office. It really makes no sense whatsoever. Again, it's hiding what may be the best evidence of abuse. And we're not talking just elderly people, which of course, somebody has to stand up to, but there's a lot of people that enter nursing homes after surgery, and they're much younger than that, and any kind of abuse or negligence can simply be covered up by the inability of the injured party to produce evidence of the neglect or abuse.
And it absolves the nursing institution or the hospital of any real liability, criminal or civil, because very often these bad things happen when, in the example you used earlier, a tube being pulled out, or somebody being dropped, somebody being given the wrong medicine, an alarm going off, and no one coming to the aid of the person. The only witness is the person who is there supposedly protecting our loved one, and that person can't be compelled to testify. The report that person makes can't be used as evidence, not even by the district attorney in prosecuting neglect or intentional wrongdoing. Am I correct?
That's correct. And what people don't understand is that they're just hurting the victim. There's no justice when you have these kinds of laws that conceal evidence and prohibit the injured person from getting any sort of justice.
Well, it does this. It discourages safety. It gives total immunity to wrongdoers, and it protects insurance companies. And after all, the insurance companies collect these great premiums. They're in the best business to be in the United States today for assuming the risk, and yet they have no risk in risk because the evidence cannot be used. And how about crippling the district attorneys so they can't even prosecute people who are intentionally doing damage to our loved ones?
Exactly, and they've made it more difficult to obtain punitive damages against for-profit nursing homes that abuse patients. Literally, now you have to prove that they intended to injure a person rather than that they were just grossly negligent. If they just failed to tell the doctor about bed sores on a person that's been lying there, so they're unattended and develop ulcers and the like, there's little or no liability.
It's been legislation to protect wrongdoers, not to protect consumers, ever since the Walker Group has been in. And I think another area that's going to touch every family before we're finished is the automobile insurance area. Boy, has there been a revolution there. And I'll say right off the top, before giving you the microphone, your insurance became worth a lot less after the new legislation went in. And insurance companies have to provide and produce a lot less, and yet they're still getting the premium. Tell us about some of the changes that came in under the Walker law.
Well, they undid much of the good that was done that became effective in November of 09 in the Truth in Auto bill that was signed into law by Governor Doyle. It made insurance mandatory. It raised the limits of liability. It required underinsured motorist coverage. It eliminated the reducing clause. The reducing clause is actually pretty ridiculous, and no legislature can really justify its existence, yet it was in the law in November of '09, and now it's taken off. It will be removed from the law in November of 2011, which is a clause that says if you're injured in an automobile accident and you get money from the at-fault driver, but it's not enough to compensate you for your injuries, before you can go to your own insurance and get your underinsured motorist coverage, you have to deduct from your own coverage that you paid for the amount that you received from the at-fault driver. So there's really no way you're ever going to get the limits of liability for underinsured motorist coverage that you pay for, that you pay a premium for. And it's not justifiable. And the definition of underinsured motorists, they're talking, it was changed in '09 to be less than your damages. Now it's back to the old law, which bases it on the limits of liability of the at-fault company and has nothing to do with your damages. So a lot of people will never be able to use their underinsured motorist coverage and will never be fairly compensated for the injuries they sustained.
Hold that thought. We're going to take our second break, and when we come back, we're going to go into detail as to how this really affects victims of auto accidents with serious damages and how they don't get the insurance benefit that they think they bought, and they certainly paid for. We'll be right back.